Western Australia is mining and resources rich, and mining and resources are integral to our economy. It's not surprising, therefore, that a lot of commercial disputes relate to the mining and resources sector. In terms of how mining and resources disputes are resolved, historically a lot of them have been resolved in litigation, but as increasingly these disputes are cross-border, we're seeing a lot more of these contracts with arbitration clauses and disputes being resolved by arbitration. I'm joined today by Craig Colvin SC, who is a founder and director of the Perth Centre for Energy and Resources Arbitration. PCERA, as it is known, was established almost exactly a year ago, and it was designed specifically to deal with mining and resources disputes and to identify innovative ways of dealing with those sorts of disputes.
I think international arbitration needs two things basically. One's good international connections and the other is industry expertise in the area. So in Perth in particular there's been a dramatic growth in international connections amongst law firms, includes HSF. That's been a big development, and also of course we've got engineers, geologists, mine managers here with all of the expertise that relate to those types of disputes. And so you put those together with people who've got an understanding of commercial issues and what the industry involves, and that's what you need for a good international centre. I think the overall development is it's just been increasing significantly. You see that in the growth in arbitration centres. Singapore has been a big development, but it's not confined to that. In Australia we've had ACICA, the Australian Centre for International Commercial Arbitration. It has good facilities for arbitration, and of course the organisation I'm involved with, PCERA, has established an arbitration centre in Perth, particularly focusing on energy and resources arbitration. That's not unique. In Scotland and in Canada there have been similar industry-focused arbitration centres, so that's a trend, I think, seeing that happening. And as a result there's a lot more choice as to the types of arbitrations that you can select, because not all arbitration centres are the same. So there's really two things that PCERA is offering that are different. Firstly, of course, the focus on resources and energy with arbitrators and mediators and procedures that are specific for that energy and resources sector. The second is a commitment to innovation. We were on that bandwagon before Malcolm Turnbull was recently, but we've embraced it with the procedures that we adopt. For example, we've developed a collaborative expert determination process. It involves the parties agreeing to identify in a two-party dispute two experts. They then draw lots as to which party they work with. One works with one party, the other works with the other, and they identify what the issues are, and then they come together and meet with a view to working out a reasoned resolution of the dispute, and will publish their decision. That will be binding or non-binding depending on what the parties agreed at the commencement of the process. So it's more flexible, it's a more collaborative process, and it works well for parties that want a long-term relationship, and it's less adversarial, and therefore it's better for supporting that kind of relationship. Also, in relation to price contracts under long-term commodity agreements, we're delivering a set of rules in the new year focused on those kinds of disputes. It's modelled on the idea of a baseball arbitration, where the arbitrator chooses between two positions, one advanced by one party and the other advanced by the other party. And that means that there is less incentive to have ambit claims, the arbitrator at the end of the day is just going to pick one position or the other, and means that the parties tend to be more reasonable as to the positions that they're adopting. It means the arbitration can be more focused, is quicker, less expensive, and gets a more reasonable, removes the risk of an unreasonable result.